Well, hello everyone. Sorry I've been away for a bit. I was traveling again, and it seems the world did not stop and wait for me. So I just want to do a quick catch-up video on several topics, and I think I'll post some of my travel photos in a separate post for anyone who might like to see that. While I was gone, Team Nautilus and Team Satterfield had big wins. Cory Fleming was sentenced and immediately taken into custody, while Russell Laffitte is still a free man and will remain so for even longer. So let's get caught up. This is Cassidy O'Connell with Legal Updates with Cassidy, where we're going to get updates on Cory Fleming, Russell Laffitte, and that Satterfield case that just doesn't end. Welcome. Before I left, a document was filed by Nautilus Insurance. It was their response in opposition to 1. Defendant Palmetto State Bank's motion for summary judgment, and 2. Defendant Chad Westendorf's motion for summary judgment. It is 485 pages, and that's just my version. It's without the Chad Westendorf deposition because I have that on video, and so I didn't download that. With it, it would have been more like 649 pages. Needless to say, I have not had time to get through all of that yet, but I'm excited to get started on that later this week. But the big news last week on August 15th was that in Charleston, Judge Gergel ruled on some important rulings in the ongoing Satterfield case. His Honor called it a blizzard of filings, and he's not exaggerating. I have that order here to use as our template today to keep things on track and in order. We start off with filing number 134, which was plaintiff's motion to amend its complaint. And here's that document. A look at page 1, we see, using Rule 15A2 as their standard, they claim the right to amend. And we went over this redline version here in the video last month. It's called Take Their Money, Not Mine. If you haven't watched that, take a look. We go through this redline version of the proposed amendment that we're talking about today. And in that filing, they state that they wish to amend because of new information learned since the amended complaint was originally filed. Now, Palmetto State Bank filed their own motion to oppose, which was document number 149, arguing that the motion should have been filed earlier and that PSB would be prejudiced by an amendment. They also argue that prosecution of the new claims would be futile, and then the clause come out. Just look at their wording. It is an unrestrained effort to capitalize on the well-publicized misconduct of Russell Laffitte, even though the actions that caused plaintiff's alleged loss have nothing to do with that misconduct. And then the fangs come out. Nautilus alleges a sprawling hodgepodge of claims, spanning everything from negligence to RICO, trying to capitalize on the unrelated misdeeds of Russell Laffitte and the bank's knowledge of the checkered credit history of Alex Murdoch. But those events are entirely independent from anything having to do with Nautilus. To which I say true, not Russell, this time. This time, it was your current Vice President, Chad Westendorf. How does the court find? First, they say it was filed within the timeline from the scheduling order. And remember, the scheduling order is a document put forth by the court that gives deadlines for each step of an upcoming trial to make sure that it's all done on time and that everyone involved has ample time to see each other's witness list, discovery, that sort of thing. And the scheduling order states, amendment of pleadings. Motions to join other parties and amend the pleadings shall be filed no later than July 28th, 2023. And this motion was filed on July 28th, 2023. The last day, but still in time. His Honor further notes that it does in fact fall under Rule 15, and he states that this proposed amendment does not appear frivolous or futile, and thereby grants it. Now, once this amended pleading is accepted by the court, we now have a domino effect, because there were a number of pending motions based on that previous complaint. So with those changes, it's now rendered some of those motions moot, and then it names a list of those that are considered to be moot by the court now. That's document number 118, which is a motion for protective order filed in June, then several documents filed in July, a motion to compel, a motion for protective order, motion for miscellaneous relief, motion to seal, and 2 motions for summary judgment. And the last one earlier this month, document number 140, another motion to seal. so these previously pending motions have now been taken off the table. The order goes on. We have filings number 132, which is Nautilus Insurance Company's response in opposition to defendant Palmetto State Bank's motion for protective order, in which plaintiff argued as part of its response to defendant PSB's motion for protective order that PSB had waived its attorney-client privilege. And then document number 136, which was Palmetto State Bank's response. How did the court rule on this? The court has denied the original motion for protective order as moot. And that was document number 124 that we just saw in that table. But that matter isn't final. The court then goes on to give instructions on how they should proceed if they want to continue down that line. It instructs, if plaintiff intends to assert that defendant PSB waived in whole or in part its attorney-client privilege, plaintiff must make a specific motion and set forth in detail its factual and legal basis for such a claim and the scope of the alleged waiver. Defendant PSB can then make a focused and complete reply to this claim. The next item in the order we also covered in the video, take their money, not mine. This was the motion to compel the joinder of Gloria's sons, Tony Satterfield and Brian Harriet, as necessary parties. If you didn't watch that, I really suggest that you do. Alex's team was trying really hard to get Gloria's sons added to this suit. He was trying to take away the money that they were compensated because he stole their original settlement claim for their mother's death. And that's what that whole motion to compel was about, trying to force the court to either add them or drop the case altogether. It was basically make them pay or let us all walk. I was really anxious to see this ruling. The order reads, plaintiff has filed a response in opposition to the motion, asserting that Satterfield and Harriet are not necessary parties, since they claim no interest in this litigation and Murdoch does not face the risk of double obligations. And this is filing number 150, where Nautilus disagreed with that motion to add Gloria's sons and the argument that they're necessary parties. Nope, we disagree. And in the end, so did the court. The court finds that Satterfield and Harriet are not necessary parties. Defendant Murdoch's motion to compel joinder is denied. And thank goodness for that. The court did not let us down. The next one is about document number 151. This was what's called a surreply by Satterfield and Harriet. The court rules, defendant Murdoch filed motion to strike the surreply because Satterfield and Harriet are not parties to this action. Defendant Murdoch's motion to strike the surreply is granted. Now this may sound like a loss for the Satterfield team because Alex's motion was granted here, but it does not really affect them since the court has ruled that they are not compelled to be joined to the lawsuit. So basically, since the court ruled that they are not to be joined to the lawsuit, there would be no reason to grant this. Their reply is no longer needed, therefore, it's not a problem that it was struck. And pardon my legal nerd sense of humor, but I have to read some of the excerpts from this surreply. It was written up by Bland Richter. I don't know which of the two. I think this might be Ronnie Richter, but Bland Richter does have the most colorful filings, and I was giggling as I read this one. It says, Murdoch's position reflects a fundamental misunderstanding of English tense. Yes, the Satterfields once sued Murdoch, which action was resolved. The fact that the Satterfields once sued Mr. Murdoch in a prior piece of litigation, as in past tense, does not in any way suggest that they claim, present tense, an interest in the ongoing dispute between Nautilus and Murdoch. Still, Murdoch's reply blurs the lines of tense by suggesting that somehow the Satterfields are pursuing an active interest against Murdoch or others. So I guess Team Alex didn't find it as funny as I did because they filed a motion to strike it and the court just granted that motion. Then we end with instructions of where the case goes from here. And that says, after plaintiff files its second amended complaint, the parties are directed to meet and confer on a discovery schedule that first focuses on the liability of the defendants regarding the payment by plaintiff of the claim arising out of the death of Gloria Satterfield. The parties shall advise the court within 30 days of this order of their jointly proposed discovery schedule, or, if no agreement can be reached, the respective proposals of the parties. And in that case, they would each bring their proposal and the court would make a ruling or a decision on that. So that is where this case is now. And he also limited discovery so that no one, in his words, will be buried in an avalanche of documents. In other words, no more 649 pages for one motion. And of note, he said something I wasn't super happy with. He said that for any defendants that have been named in this suit so far to remain named defendants, there must be proof that they knew about the plot to steal money. So this could possibly be Chad Westendorf's way out. If they can't prove that he knew that money was going to be stolen, they may be compelled to drop him from the suit. Personally, I would have thought knowing how structured settlements work, or something you should have known, and seeing money left over in accounts, also after getting instructions not to disperse till it's properly filed in court, which in a previous video we talked about, Chad had that in the instructions that came with the settlement checks, that he signed over 2 checks, both with the same instructions. These checks were not to be dispersed until the paperwork was properly filed in court. He also testified in his deposition that he was there, present, and heard Cory Fleming discussing with Judge Carmen Mullen that Alex did not want these documents filed because he was trying to avoid paying out for the boat crash. This was way back before Paul and Maggie had been murdered. They were trying to keep this settlement off the record so that Mark Tinsley would not be aware that he had just acquired a multi-million-dollar settlement for his clients. Now, Chad Westendorf heard all of this. If you're a law-abiding citizen and a proper bank head, vice president of a bank, and you hear things like this, would you not wonder if you receive instructions on a multi-million-dollar check that say do not disperse these funds until these documents are properly filed in court, would you just sign it over? I think it's a stretch to claim complete ignorance and innocence here, but that's just my opinion. But seeing this shady stuff, also seeing money left in the account for quite some time and then drawn out again, I think it's a pretty good indication that you know you're not doing things right. Also, in my reading in that large file, there is a bank policy manual that clearly states that bank employees should not serve as personal representatives unless it's for their family members. As vice president of that bank, he should be familiar with the policies because part of his job would be to enforce those policies. So the fact that he took on this role as personal representative against his own bank's policy also undermines innocence. But it's looking like unless they come down a little harder on Westendorf, come up with a little more proof, he might just weasel himself out of this. But I still am left scratching my head as to why Judge Mullen has not been called out for her part in this. Moving on to our next news, Cory Fleming was sentenced for his hand in taking money from the Satterfields and the Pinckney family. At the end of the hearing, he was taken immediately into custody. His entire process only involved a total of 35 filings. The first one on May 23, 2023. And that was his information filing. This outlines the role that he played in stealing money. He still denies knowing about Alex's fake forge accounts, but he did admit to submitting false disbursement sheets to the court and charging false amounts in attorney's fees that he kept for himself. Personally, I think it's probably true that these guys were unaware of Alex's forge account, since they might have asked for bigger shares in the profits. If they had known he was walking away with millions of dollars, and they were getting much smaller cuts in comparison, they might not have been too happy about that. And Alex also, knowing that they were getting much smaller cuts than he was taking, might have been a little skittish about letting them know his full plan. And to me, this shows a little more of Alex's character, just how evil he can be, that no one, not his law firm, not his friends, even the ones that were in on it, even his family, none of these people are off limits when he wants something. And they've all now learned this the hard way. Some paid with their lives, and some paid with their freedom. Cory's plea agreement was filed on May 24th of 2023, and it stated that the maximum prison term would be 5 years. His judgment was filed on August 17th at his sentencing hearing, and as I mentioned, he went immediately into custody. Looking at his judgment here, he was sentenced to 46 months in prison. You can see this is the same form I mentioned when I went over Russell's, that this is kind of a fill-in form for all prisoners, so not everything on here applies. But it will run, just like Russell's, it will run concurrently with the anticipated state sentences. So again, if the state sentence is shorter than 46 months, once he's done with this federal time, that's it, he's released home. He would only serve more state time if his state sentence were to come out longer, which in Cory's case is probably not likely. Then he has restitution to pay. He has to pay a $100 special assessment fee, and then his fine is $20,000. The restitution amount, $102,221.90. Just like Russell, it's all due immediately, and if there's anything left owed when he's released, there would be payments made at that time. But his restitution is due immediately as well. The court recommended the same facility that they recommended for Russell Laffitte, the FCI Jessup, and they also recommended him being screened for participation in the residential drug abuse program. If inmates participate in programs like this, it can go towards helping them get reduced sentences. And then it states, unlike Russell Laffitte, the defendant surrendered immediately following his sentencing. He's like, I just want to get it done, get it started, get it over with. The sooner I get in there, the sooner I get out. Then after his prison term is finished, he also has a supervised release like Russell Laffitte, but his is shorter, it's 3 years. And then, like I said, any unpaid fines would be put on this payment plan of $250 a month, 30 days after his release. And then again, this is the standard form for all prisoners, so it just lists the conditions such as not committing another crime, not using controlled substances, or even possessing them. He has to make restitution, and he has to cooperate with the collection of DNA. Then they made a chart of his monetary penalties. As mentioned, it was the $100 assessment, the $102,221.90 restitution, and the fine of $20,000. And then it shows where these go. We don't see the Satterfield boys here because they've already been compensated by Cory and his firm. So what's left is Hakeem Pinckney's mom, Pamela, to whom he must pay $13,088.46. And then we have Parker Law Group, which is Alex's former firm, formerly known as PMPED, and it's to be paid to Ronnie Crosby, just like Russell Laffitte's was, and that amount is $89,133.44. So Cory's case was all very clear, clean, and concise. If you're going to be a bad guy, this is how you make it right. Waste as little of the court's time, taxpayers' money, and put less pain on your victims. Just admit it. Acknowledge the pain you've caused. Compensate your victims, accept your punishment, and be done so you do less damage and let people start their healing process. Even Attorney Limehouse remarked on the night and day difference between Cory and Russell, with Cory pleading guilty and cooperating fully, compared to all the trouble Russell has caused and continues to cause.
If every single person acted like Russell Laffitte, we simply would not have the resources to hold individuals accountable. So when someone like Cory Fleming comes in and takes full responsibility and cooperates with us, it promotes respect for the law and our efficient administration of justice, and we believe they deserve some recognition for that.
It shows up in their sentencing as well, with Cory receiving just under 4 years in prison with 3 years supervised release at the end, compared to Russell's 7 years and 5 years supervision. I was happy to see Gloria's son Tony and Hakeem's mother Pamela Pinckney with their respective attorneys, Eric Bland and Ronnie Richter for Tony, and Justin Bamberg for Pamela.
I just pray that, God give Cory Fleming the strength to get through what he got to go through. Just as well as me and my family, God give us strength to go through what we got to go through.
I can't speak for him. I sure hope he does, but if he doesn't, I still forgive anyway.
These victims are so sweet and innocent to me. How can anyone have looked at them and wanted to harm them so? I'll never understand, but I felt they carried themselves with grace at this hearing. And lastly, on this matter, I wanted to share a delightful clip from Mr. Richter, Ronnie Richter, of Bland Richter, who I think has just this wonderful way with words. I always enjoy the way he writes in his filings too. He said, "Hate the sin and not the sinner." I don't hate Cory Fleming, but I sure don't like what he did to the Satterfields. Crime always runs ahead of justice, but crime is a sprinter and justice is built for the long run. Isn't that a great quote? I really liked that. Now, speaking about the contrast between Cory and Russell, our last piece of news is about Russell. After being found guilty, filing and being denied a new trial twice, he's not only filing another appeal, but also asking to remain free while awaiting the appeal. Now, with his case, his filings began on July 20th, 2022, and are now up to document number 323 that's been filed in court, and there is no end in sight. How much of the court's time has he wasted? How many tax dollars has he wasted in an economically depressed town? It's shameful. You're guilty, Mr. Laffitte. There's no denying it. There's no stopping your prison term. Just stop wasting time and money and causing your victims more harm. Okay, off my soapbox. He was finally given a date to self-report for his prison sentence, but he's asked for an extension and, unbelievably, been granted one. So let's take a look at those latest documents. So this was filed on Friday the 18th in the 4th Circuit Court of Appeals, and it reads, on August 14th, Laffitte filed a motion for bail release pending appeal. It is anticipated that he will be designated to report to a Bureau of Prisons facility within the next few weeks. On August 15th, this court directed that the government file a response on or before August 22nd. On August 17th, the government filed a motion requesting an additional 3 days because they needed to rely on a transcript, which they indicated they had received that same day. So this part was a delay from the government. They were waiting for a transcript before they could file a motion. And now here is his notice of appeal filed on August 8th. And you know what? At this point, I'd love to see the opposite of rewarding good behavior here. You know how prisoners get less time for good behavior? Wouldn't you love to see that for wasting the court's time and resources, that you could add time for bad behavior? I mean, just my thoughts. Moving on, back to this document. It says, earlier today, August 18th, Laffitte received his designation letter from the United States Marshal Service with a report date of September 14th by 12 p.m. Laffitte almost certainly intends to file a reply, and that would be his motion for bail or release pending appeal. So he's filed this appeal, and he wants to stay out of prison while awaiting the outcome of this appeal. So his counsel has contacted the government and asked the government again if they would consent to an extension of his report date. So he was scheduled to go in on September 14th, but now they're asking, can we get an extension? Because what if he gets this release pending appeal? So the government consented to a 1-week extension, making his new reporting date to start serving his sentence September 21st. And of course, that hinges on what happens with this appeal and his motion for release pending appeal. So all in all, a big win for the Satterfields and Nautilus. Cory's prison term has begun, and Russell is still avoiding his prison term. It's up in the air whether Chad will remain a named defendant on the Nautilus case. So after this video, I will be buried under an avalanche of these documents, but I will be back soon. As always, this is Cassidy O'Connell saying stay well and stay tuned.